Welcome to our panel discussion on the Paris Agreement and the future of climate law. I am Hari Osofsky from Penn State Law and the School of International Affairs, where I'm the dean. And I must make the disclaimer that though I really delight in representing Penn State University, the views that I express over the course of the panel do not in any way represent the viewpoints of the university. I also want to thank Jackie and Anita again in our officially recorded session for the tremendous job they've done in organizing and hosting this wonderful gathering. And I should say that my role in this panel will be to serve primarily as moderator. We have two amazing panelists. There will only be one exception, which is question 2, and so I will leave you to wonder what that might be. That is the one thing I feel like I have to say something about. To my left and your right, Lisa Benjamin is an assistant professor in the University of the Bahamas LLB program, where she teaches environmental, trade, company, and intellectual property law. She's a member of the Compliance Committee, Facilitative Branch, of the United Nations Framework Convention on Climate Change, the Bahamas National Climate Change Committee, the Bahamas Trade Commission, co-founder of the Climate Change Initiative at the University of the Bahamas, and founder of the Environmental Law Clinic, a collaboration between the University of the Bahamas LLB program and the Udine Dupuch Law School, and is a fellow-elect at the Oxford-Princeton Global Leaders Fellowship Program. She's a director of the Bahamas Protected Areas Fund and has been advisor to the Bahamian National Delegation to the United Nations Framework Convention on Climate Change process. Her current research looks at climate change in small island developing states, trade and environment law, carbon major companies and climate change, and energy in developing countries. Lavanya Rajamani, to my right and your left, is equally qualified to talk on this topic. She's a professor at the Center for Policy Research in New Delhi, where she researches legal issues relating to the environment and in particular climate change, international law, and human rights. Professor Rajamani is the co-author of a number of publications, and a number of really understates that, on climate change, including International Climate Change Law, recently out from Oxford University Press. She's taught at Queen's College, Cambridge, where she was a university lecturer in environmental law, and fellow and director of studies in law at the Worcester College in Oxford, where she was a junior research fellow in public international law. She taught or is scheduled to teach international climate law, change law, international environmental law, and human rights at, among other places, Oxford and the Hague Academy of International Law. She holds an LLM from Yale, a DPhil and BCL from Oxford, where she was a Rhodes Scholar, and has worked on climate change negotiations for several years, I'd say more than several, in various capacities, including most recently in the UNFCCC Secretariat's core drafting and advisory team for the Paris Agreement. As she mentioned earlier, some of the stuff that she drafted is actually in the Paris Agreement. So we have two incredibly well-qualified people who've been deeply involved in these negotiations for many years, and what I want to start them off with is, what were the major achievements of the Paris Agreement in your view? What are its key gaps? How important are the ongoing negotiations for a Paris rulebook, and what are the key challenges to designing a robust rulebook by 2018? So maybe we'll start with Lavanya for this one.
Thank you, Harry. The Paris Agreement, I think most of us would agree, was a tremendous achievement. Not just in multilateral diplomacy, we got much further than we expected to get, but also in terms of setting a new paradigm for international climate change law. So what do I mean by that? In terms of actually going further than we expected, and many of us who were part of the negotiations or were in various capacities working on the negotiations in the belly of the beast, as it were, had limited expectations of Paris. We thought we would get somewhere. We would have an agreement because there was tremendous pressure to have an agreement, but we didn't really think we would have a robust or ambitious agreement. But we did, to some extent, have a fairly robust agreement and a fairly ambitious agreement. It's qualified, of course. But in terms of its actual achievements, what do we have? We have a long-term global goal, temperature goal, which, albeit parts of it aspirational, 1.5 degrees. We never thought we'd get 1.5 degrees in the agreement. So we have that, and that was a tremendous achievement for the small island developing states in particular, who lobbied very hard for it. We have binding obligations of conduct on all parties in relation to preparing, communicating, and maintaining nationally determined contributions. Again, it's for all parties, not just developed countries. So that was a tremendous achievement from what we had before. It also contains very strong normative expectations. And to some extent, these normative expectations are at the core of the Paris Agreement's deal. So we have strong normative expectations on progression, that every successive nationally determined contribution will represent a progression on the previous one, that it will represent the highest possible ambition. And these strong normative expectations, including actually leadership from developed countries on progression and highest possible ambition, are central to the deal in the Paris Agreement, because without that, all you have are NDCs from countries, and they're self-determined, nationally determined contributions. So that those normative expectations are very much part of the deal. And we also have elements of a potentially robust top-down oversight system. So the transparency system, the global stocktake, and compliance and implementation, all of which are currently being worked out. So we need to see how robust they actually will be, and how we're going to get to 2018, a question that I will come back to in a minute. But in addition to these sort of key sort of elements of the Paris Agreement, there are also, of course, sort of various sort of elements that represent a new paradigm in international climate change law. And what are these elements? For one, I think it represents a hybrid architecture, represents hybridity in legal form and character, and represents a new form of differentiation, at least within the context of climate change law. So the Paris Agreement is, of course, an internationally legally binding instrument. There's no doubt about that. So the legal form of the agreement is clear. But the legal character of provisions within it sort of cover a vast spectrum. So at one end of the spectrum, you have provisions that actually are very clear, very precise, lend themselves to assessments of compliance and non-compliance, are actually legally binding obligations, and albeit of conduct, but they're legally binding obligations. And at the other end of the spectrum, you have actually provisions in the operational part of the treaty that perform a narrative function or a storytelling function, that are just contextual. They don't actually contain any standards for state behavior. And somewhat unusual to see those kind of provisions and operational provisions of a treaty. But they performed a valuable function nevertheless. So there is some hybridity in the legal character of the provisions within the Paris Agreement. There's also hybridity in the architecture, and in some respects that represents a departure from the Kyoto model, which is very much a prescriptive top-down model with targets and timetables backed by a compliance system. What we have here is sort of self-determination with NDCs and an oversight system, which, as I said, is still to be worked out. And the third element, I think, that's a distinctive element about the Paris Agreement, and it represents a new paradigm in a sense, is how it addresses differentiation. So differentiation in the climate change context has thus far been very much sort of categories of parties and tailored commitments to categories of parties, whereas the Paris Agreement takes a very different approach in different areas. For instance, in mitigation, the approach is one of self-differentiation. Every country chooses its own nationally determined contribution, so differentiates itself from every other country as a result. And in other areas, you have somewhat more category-based differentiation, perhaps in finance, where you talk about developed and developing countries. So essentially, there's tailored differentiation based on the issue area, not differentiation tailored to categories of countries. So there is a sort of whole new paradigm as far as climate change law is concerned. But this whole paradigm does leave certain gaps. And the gaps, in particular, are that if you leave the NDCs and you leave parties to determine their own NDCs, they're not going to add up. So the question really is, does the bottom-up add up? And the bottom-up doesn't necessarily add up. And if you look at all the assessments that have been made so far about the NDCs, you see that the NDCs that have been submitted are sort of most likely to taking us on a path to 2.6 to 3.1 degrees centigrade by some assessments, and even more so by other assessments. So we do need very robust top-down rules to be negotiated, and that's a sort of key challenge for 2018, to negotiate these robust sort of top-down rules. And differentiation, it's come to be seen, the compromise that was sort of reached in Paris on differentiation, the kind of new paradigm I'm talking about, was a fairly tenuous compromise. So the differentiation issues have sort of resurfaced in the current negotiations, and we are finding it harder and harder to actually reach a robust set of rules that are tailored to flexibilities of countries and are not tailored to categories of countries in a sense. So I think there's a challenge in the ongoing negotiations, in particular on differentiation across issue areas. But I'm going to leave some of the details of that for sort of further questions.
I think, obviously, Lavanya's response is very comprehensive. Whenever I talk about the Paris Agreement, I always crib from George Monbiot from The Guardian, his quote afterwards, which said, for what it could have been, it was a miracle. For what it should have been, it was a disaster. And so, the history of these negotiations is very contentious. There was, no guarantee we'd come to an agreement at all in the end. And so the fact that there was this agreement on differentiation, all these different areas, it's very broad. Up until this year, I would have said universality of participation was a really positive element of the Paris Agreement. So it definitely sets what people call the direction of travel. The problem for vulnerable countries is it doesn't establish the speed of that travel. So how quickly are we going to be able to achieve, for example, the long-term temperature goals? There's nothing in the agreement that has really strict obligations for these contributions to amount to the long-term temperature goal, and 1.5 was an achievement for SIDS. We fought very hard to get it in the agreement, as well as the well below 2 degrees. But unfortunately, at the moment, it's just a marker of the ambition gap. And so as time proceeds, and 2018 is a really important year for 1.5, if ambition is not ramped up within the agreement, it's just going to really mark the lack of ambition within the parties to achieve these long-term temperature goals. And so that's one of the major achievements is the long-term temperature goals. One of the major weaknesses is there's no real binding mechanism to make sure that we achieve those, because a lot of the Paris Agreement are collective obligations. So it's not individual obligations on parties. There's no individual obligation of result. There's obligations of conduct. And so the Paris Agreement is successful as a procedural agreement. I mean, it's, everybody is participating and they have procedures that they have to follow, but it's not very successful in terms of achieving results that are listed in the agreement itself. And so, the transparency framework was a very important mechanism to really elaborate a managerial model of climate change law now. So this is going to be sort of basically a name and shame approach. So how are we collectively achieving or missing these targets that we have set? And the Paris Agreement doesn't really establish a mechanism to hold a single party to account to achieve certain things. So the global stock take is a collective assessment, and the compliance mechanism will bite on individual party obligations, which are obligations of conduct and not of results. So it will be really interesting to see if this experiment in managerialism for compliance really works in the end. So there are obligations for progression over time. Loss and damage was a really important win for SIDS. We'll talk about that in a later question, but it's really declining in terms of being able to have that as a hook for ambition. Over the past few years, particularly at this COP, we saw that loss and damage was really minimized in the negotiations, despite what's happened this year. So it's really important. The next year, 2018, will be a big year for really translating what are these very big concepts in the Paris Agreement into sort of technical rules. So, negotiating this Paris rule book will be very important next year. 2018 is also a really big year because the IPCC will have a special assessment report on 1.5, and then there'll also be a facilitative dialogue in 2018 to really see where we're going. So this COP has basically been a very technical COP, and sort of this delicate tapestry of the Paris Agreement of differentiation, you can see that this is sort of pulling apart a little bit as developing countries try to put things in that they were disappointed were excluded. Developed countries are trying to say, no, let's stick to exactly what we've agreed. So it's going to be an interesting year in 2018. I try to be hopeful, but it's tough, I have to say, sometimes. And so we'll see what the next year brings for 2018. But yeah, it is an achievement, but I think being able to get to the results that we want, it doesn't provide us the mechanism to get there.
So thank you for this sort of thoughtful big picture. I now want to hone in on the elephant in the room, which has already been referred to, which is how the U.S. withdrawal will affect the implementation of the Paris Agreement. This is the question that I said I was going to say a little something on. Not actually on the answer to that question, but I thought it would be useful for me to give a little bit of context as the U.S. person in the room of what's going on domestically around the context of the Paris withdrawal, and then let you all speak to this sort of the broader international implications, namely how the lack of U.S. participation in the regime, or how the U.S. continuing to participate in the regime in the meantime before the withdrawal is complete, is likely to affect the creation of the rule book, the overall understanding underpinning the Paris Agreement, and also sort of speaking to questions of the role of non-state actors in all of this and subnational actors. So I just wanted to briefly say, as someone who was sitting, to me, almost as exciting as the moment when the gavel went down in Paris. I was representing, I was leading the ASIL delegation to the Paris negotiations, the American Society of International Law. For me, almost as exciting as someone from my country who's watched this progression was to be in the room when the United States delegation walked in as a member of the High Ambition Coalition to a standing ovation. I'd never thought that I would see my country in a climate context walk in as part of that group and to a standing ovation. I think there was a great hope at the time that this wasn't going to be like the normal U.S. approach to international law, and in fact the treaty was designed to avoid it. So one of the problems that the U.S. has had historically in all sorts of different international law contexts is the way that our Senate treaty ratification structure happens, that process happens, often really makes it difficult for us to actually join agreements after we negotiate them. And so our pattern has been to be very active in shaping agreements. Obviously, a big part of why Europe has an emissions trading system was our involvement in the Kyoto negotiations, which we then obviously didn't become part of. And there are lots and lots of examples of this. So, one of the reasons that some of the wording is as it is and is less, it's some of the places where it's less binding in the Paris Agreement was, of course, in order to make it so the U.S. could join without it going through the Senate, right? So that President Obama could use that the other part of the treaty power. And so, of course, no one quite foresaw what would then happen in my country. And so I think there are a couple of, so on the one hand, it's a complicated story to tell, right? Because I was always worried about whether we were capable of meeting our targets with the plans that we had, right? I think that was always, and for so many countries this is the case, it's not just a U.S. story. Obviously we're not meeting those commitments now. But I think the thing to recognize about the United States, and this is sort of the ray of hope thing that I want to sort of say in this context, is first of all, Hannah Wiseman and I actually put a piece in the conversation when Trump got rid of the Clean Power Plan. And essentially what we said was that though this looks like a major policy change, and in fact it is, as are some of his efforts to subsidize coal and nuclear, that it's important to remember that fundamentally the impact of all of this is blunted by the way energy markets work in the United States. The most significant energy transition that's happened in my country and in many countries is the advent of hydraulic fracturing paired with horizontal drilling technology, and the transformation that's created in terms of sources of energy that fuel our markets. We have regional markets in the United States that operate on a least cost basis. And so natural gas and renewables are very competitive in those markets, and depending on the market, what percentages. But I think, and so I think that's unlikely to change, even if we don't have the kind of ambitious federal policy that it looked like maybe we were going to have, assuming it survived judicial challenge. I also think that the subnational and the corporate becomes very important in this context. So, there are a number of states in the United States and cities in the United States and companies in the United States, and really big, important companies, including some oil majors, which have pledged to meet Paris commitments. And so that also blunts the impact of the decision at a federal level not to participate. And so I say those things not in any way to paint a rosy picture of what's going on with my country. And obviously, there are really significant difficulties that are created by the biggest developed country major emitter deciding to withdraw from this agreement after after they got to, I think, the most ambitious point that they were politically capable of getting to in the global community in Paris 2 years ago. But I do think that It's not quite as big a gloom and doom story as it often gets portrayed at, because there are a lot of things that, well, the same things that were making it hard for the U.S. to meet its commitments, to really push its ambition up, are the same things that are blunting how much the ambition level is going down. So with that,
Yeah.
maybe you want to talk to the international implications. We'll start with Lisa this time.
Yeah, so of course, when we were in Paris, the U.S. negotiators were telling me we have to have this language because of our Senate and all that stuff. We're just going, okay. And that was probably very happily received by other countries as well. It's not that it was just the U.S. and then they leave and you just think, all of this work and effort. So, that was a real shock. And of course, we've been here before with Kyoto. And I can't remember which negotiator told the U.S. delegation this a few years ago when they were in. I don't know if it was Papua New Guinea or the Marshall Islands. And so the comment they made to the U.S. when the U.S. was being very obstructionist several years ago is either lead or get out of the way. And
Papua
this
New
is
Guinea,
Papua New Guinea, yeah. And so this is my concern now with the U.S. negotiating team still being part of the negotiations on the Paris rulebook, is how obstructionist are they going to be while the rest of the world is trying to. I have two concerns. That's one of them, trying to really hammer out the details of this agreement, which is extremely important. And so I spoke to a couple of colleagues, non-U.S. colleagues, about how it was going and how the U.S. negotiating team were sort of behaving, I guess. And the reaction they gave me was that they were very quiet. And I don't know if this is still the case in COP23, if that was still the case, but the U.S. negotiating team was very quiet, and so not obstructing. And that's a good sign for now. What happens in 2018, we'll see. And a lot of U.S. negotiators have left, so Sue has left, and the State Department's kind of been decimated, and so there's been a huge change in the negotiating team anyway, and in a number of negotiating teams, which also has implications for how you interpret the language that was negotiated carefully by other people. So you have new teams in who are looking at this language, possibly without the same concepts and understandings that were hammered out before. So, the obstructionist element of the U.S. negotiating team I was very concerned about, and we'll have to see what happens in the next few years, because the U.S. can be very, very vocal and very, very difficult to deal with in the negotiations if they want to be. The second concern I had about the withdrawal ongoing in the Paris rulebook was this sort of, the only way I can describe it is an informal drag on ambition of other countries. And so I spoke to a colleague from an OECD country, not a particularly progressive one, and so his approach of his government was, of course, we're going to comply with Paris. And everyone has been very clear that without the U.S., the world is going to proceed. And so his country's approach is, of course, we're going to comply with Paris. Of course, we're going to comply with our obligations. But now the U.S. is left. Well, but how? How are we going to do this? And so, it gives sort of impetus to what I would call the coalition of the unwilling to kind of sort of backtrack on what they had agreed to do and sort of deflate ambition out of these contributions. And that's my second major concern, is it sort of acts as this informal drag on ambition. That's, really we need to sort of ramp up ambition, not sort of deflate it. And so that's my other real concern with the U.S. departure. The interesting thing about the withdrawal is that it really shifts leadership roles. The U.S. was not leading for a while, then it led, and now it's gone. And so it really shifts it to developing countries, which I think is really interesting. And, at least formally, the Chinas and the Indias, and, they've all said, yes, we are going to lead. And I think that's a really interesting approach of developing countries who for a long time have said this is not our responsibility. We should not be leading this because we didn't cause it. And so I think that shift has been interesting. Because of the reducing cost of renewable energy, I'm hoping that it's hopeful. I'm hoping that developing countries can sort of use the reduced cost of renewable energy to, serve their development needs and their poverty eradication needs, which is one of the main concerns you hear from developing countries for not committing to reductions. So, it'll be interesting to see that shift in the negotiations, and of course, the EU and possibly Canada. They have some iffy issues with their pipelines and their oil sands, but possibly Canada will take on that role as well. So I think it'll be interesting to see the shift, and we just have to see how it plays out. Of course, it's disappointing, but there's not much you can do about it, so you have to kind of move on.
Well, it's certainly true there's not much one can do in terms of actually getting them to participate, but I think there is something the international community can do to frame and sort of limit their non-participation, I guess. So one of the things I think that's useful to keep in mind is that the U.S. did have the option of going nuclear, as it were, as far as leaving the Paris Agreement is concerned. Under the terms of the Paris Agreement, they can only sort of leave 3 years after entry into force for the US, and it takes 1 year to take into effect. But if they had actually chosen to withdraw from the UNFCCC, they could have sort of left within a year, because the Paris Agreement is a rated legal instrument, and they could have left. So they chose not to do that, and I take some comfort from that. They chose not to do that. To the extent that one can read the tea leaves or read the sort of various sort of garbled messages coming from the Trump administration, they do occasionally say things like, sorry, they do occasionally say things like, well, if we can renegotiate the terms of our sort of engagement in relation to the Paris Agreement, maybe we'll still stay in. And so it's worth keeping in mind that they've announced and communicated their withdrawal, but it's not actually going to start taking into effect until 2019. So what are they doing in the meantime, and what can the international community do in the meantime? And I think in terms of what they can do, they can actually downgrade their NDC, which would mean that they would effectively have renegotiated the terms of their engagement with the Paris Agreement. And this is something that is not outside the realm of possibility, perhaps in part because this administration seems quite keen to step away from any of the legacy of the previous administration, so it seems like something they might well do, and that might actually mean they stay in the agreement. And there's been actually quite a lot of debate about keeping them in the agreement and at what cost. So should we actually allow the US to downgrade their NDC if that was the term on which they would re-engage with the Paris Agreement and not actually leave in 2019 as they said they would? And I think there are some differences of view on this, because there are, of course, those who believe that we should keep the US in at any cost, even if they downgrade their NDC. And I personally don't think we should do that because of the normative expectations that underpin the Paris Agreement, which is very much about progression and highest possible ambition. So technically, the provision that actually deals with adjustment of NDCs, Article 411, doesn't either prohibit or permit downgrading of NDCs. And you could interpret that as allowing downgrading of NDCs, or you could interpret that as prohibiting or preventing downgrading of NDCs. I think the interpretation, and according to the Vienna Convention of Law of Treaties, the interpretation should depend very much on the context. And the context is one of sort of forward movement, is one of highest possible ambition and progression. And if you undermine that, if you allow countries to downgrade their NDC, even if if it's just the US that allowed that exceptional sort of situation, it undermines, I think, the normative basis for the agreement. And in the context of the new paradigm that the Paris Agreement represents, I think that would actually really undercut the foundations of this agreement, the spirit of the agreement, and we should not allow that to happen. So I think if the US does come forward and say, well, we'll downgrade our NDC, the other countries should actually step in and say no. I don't think they will say that, but I think they should. I think what's most likely is that they will make noises about it but accept it, in part because the Paris Agreement doesn't actually have any mechanisms to prevent countries from downgrading it. So countries put in their NDCs, the Secretariat has no sort of substantive function, it just has to take them in and put them up on the website. So they can't actually technically prevent countries from downgrading their NDCs. It's also complicated because we actually don't know what downgrading an NDC means. We don't know what highest possible ambition means. We don't have any concrete content to that. We don't know what progression means. Does it mean progression from one type of NDC to another type of NDC, from a sector-wide NDC to an economy-wide NDC? Is it progression in terms of stringency? There's so many factors that go into determining what makes a more ambitious or less ambitious NDC. So there's a lot that is at play here, and a lot that is very fluid here. So practically it might be difficult, but as a matter of principle, I think other countries should actually say, no, we're not going to allow you to downgrade your NDC. So that's one reaction one could have to the US sort of potentially wanting to re-engage the terms based on the terms of the new terms and renegotiate the terms of their engagement with the Paris Agreement. I think in terms of implementation of the Paris Agreement without the US, I also have a somewhat optimistic view on this, as Hari did. I think at COP23 we saw sort of the VR still in sort of platform really sort of putting out their views there, and these are leaders from industry, mayors, cities, and college leaders. I don't know whether Penn State is part of this.
It
but
is.
It is.
Penn State is part of We Are All In.
We're still in.
We're still in, yeah. Sorry.
So, together.
Our diversity initiative is called All In. Yes.
So it does.
But we are part of We're Still.
Yeah, and it represents, by some assessments, the third largest economy in terms of the sort of, I think, $6.3 trillion or something that it represents. It actually represents the third largest economy apart from the US and China. So it is actually a substantial sort of cause for hope. And it's also interesting because this new paradigm that I keep talking about in the Paris Agreement is about decentralization. So actually, if the action is happening at the subnational level, at the non-state level, then that's exactly what the Paris Agreement was intended to do anyway and was relying on anyway. So if it's happening with or without federal sort of approval or federal policies sort of supporting that, that's actually just fine, as long as it happens. So they have committed to meeting the US NDC anyway. In terms of whether, and this is the final point I'll make on this, in terms of whether the US is being obstructionist or not in the current negotiations, they are relatively quiet, it's true, because for one thing, they've sort of radically sort of limited negotiating team compared to in the past, as you referred to. I think they had between 15 and 20 negotiators at the COP, which is a really small negotiating team for the US. They come there with like 150 at least. So it's a really small negotiating team. And there are some areas in which they have sort of put the stake in the ground, so it's not probably sort of in all areas that they're being quiet. So for instance, in compliance, one of the things that the US negotiators made quite clear is that the only trigger they would accept for the compliance system was self-referral. So, and that is obviously to preserve as much autonomy for themselves and for other parties by extension, but for themselves as they could, so that the compliance system and the implementation mechanism would not actually be triggered apart from if parties chose to trigger it vis-a-vis themselves, right?
Wouldn't actually function.
Yeah, and it may never be functional if that's the only trigger that you accept. But of course, the other parties, again, are sort of taking U.S. positions with a pinch of salt because they don't really want the U.S. to be fundamentally determining the contours of an agreement that they are most likely not going to be part of. And in the past, we've let them determine the fundamental contours of agreements, whether it's the Kyoto Protocol, which had their fingerprints all over it, or the Paris Agreement, which has their fingerprints all over it, and then they reject it. We're certainly not going to let them sort of determine the fundamental contours of an agreement that they've claimed they're not going to be part of. It's also interesting, I think, to look at the U.S. closing statement at COP23, and I found one particular phrase which I'm going to read out quite interesting. They said, "The decisions adopted at this session are without prejudice to our future positions on the matters addressed at this session." So, and this was their written submission, and their sort of verbal submission at the closing session of the COP was to basically say, well, you might have adopted some decisions, but we might have future positions that go against these decisions, and we're retaining our right to have those future positions on the decisions that we are part of, that we've taken at this at this meeting. So that's it might be just to cover their bases, like Hari's sort of non-disclaimer clause right at the beginning. But having said that, it is a somewhat nonsensical sort of intervention at the end of a session at which they were actually part of decisions and then decision-making process. So, yeah, I mean, maybe they won't fundamentally determine the contours of the rules under the Paris Agreement, but they certainly have the ability to create a drag in the process.
So I note to our panelists that I'm very much appreciating your thoughtful answers, but we have 27 minutes left.
Mm-hmm.
So keep that in mind. One of the things we've done, Jackie, you'll be pleased to know, is divide up who's going to do questions 3 and 4 and then come back together for 5. So that should help us. So I'm going to turn now to Lavanya for our third question, which is sort of pivoting beyond the United States. What role are major developed country, major emitters playing in moving the level of ambition forward? So developed country, major emitters besides my home country. And what role is likely to be played by major developing country emitters, such as India in global climate law, moving forward? And we've already heard a reference to sort of the new leadership role of China and India. And how, if at all, related to sort of both groups' interaction with this, can we ensure equity between nations in addressing climate change under the Paris Agreement's framework?
Okay, so I'll try to be brief, although that's quite a vast topic to cover. So as far as major developed countries are concerned, apart from the US, which we've discussed in some detail, I think the fundamental demands of the major developed countries are pretty much the same that have been in the process since the beginning of the negotiations, which is to demonstrate leadership. And in the context of the Paris Agreement, it is to demonstrate leadership through action, through their NDCs, and through implementing their NDCs, to be able to demonstrate not just that they're taking ambitious and progressively ambitious sort of NDCs in future, and that they're going to use the systems that are being created to actually ratchet up their NDCs, but also to ensure that they take developing countries with them, provide the kind of support that they need to take ambitious actions as well. In the context of the sort of US situation, I guess the other developed countries also have the responsibility perhaps to step up. There is going to be a finance gap, and they have a responsibility to step up. They're not going to be able to plug the finance gap left by the US sort of interventions most recently, but they do have an obligation to step up to some extent. And I think also, and this is one of the things that came out very sort of clearly through COP23, is to sort of demonstrate action pre-2020, because pre-2020 or sort of the pre-2020 situation does frame the burden for the post-2020 regime. And given the pre-2020 regime is built very much on leadership from developed countries, built on sort of implementing Kyoto commitments, that leadership and that implementation that is required pre-2020 is quite important as well. And developing countries really did emphasize that in COP23. So I think that's important. I think given the NDCs, as you mentioned, are sort of subject to obligations of conduct rather than of result, it's important for countries, particularly developed countries, to be able to demonstrate through the actions that they take and through sort of reporting on their actions that they are implementing and achieving their NDC. So although they don't have obligations of result, they need to be reporting on measures that they take, and this is part of the transparency framework, measures that they take to demonstrate implementation and achievement. Whether they can be held to account if they don't comply with it or not, they still have to demonstrate that they're taking measures to implement and achieve. As far as developing countries are concerned, again, as you mentioned, Lisa, I think the U.S. situation has sort of shifted the onus to some extent on other developed countries, but also major developing countries. And some countries have stepped into the breach. So Canada, China, and the EU have now taken on what used to be the Major Economies Forum, and which actually provided very valuable signals to the official negotiating process. They've now started the MOCA, which is sort of a ministerial on climate change that is being sort of organized by these three countries, and which to some extent forces these three countries and their groupings rather to sort of be on the same page as well. And China has a lot of influence in like-minded developing countries, which are at one end of the spectrum on issues like differentiation, for instance, and so it can actually compel and trigger certainly, but maybe even compel sort of deal making at the end. So it's quite important that these other countries and groupings are coming together in this way. And I think developing countries, not just China, countries like India, and I should mention, and sort of I'm obliged to mention, that although we are the fourth largest emitter in per capita terms, we're a quarter of the OECD sort of average, so we're always very resistant to this major emitter tag. But having said that, we're the fourth largest emitter in sort of absolute terms. I think developing countries, and particularly countries like India that have serious energy poverty and energy security challenges and poverty challenges, will have to chart their own path and take into account multiple objectives when they're sort of meeting climate objectives, and we'll also have to focus on adaptation and resilience. And we have to do all this in the context of actually limited national resources, because it's very clear that we're not going to get a big piece of, first of all, the pie is not very big as far as finance is concerned. And if anybody's going to share in that pie, it's going to be small island developing states, and others. It's not going to be countries like India. So even though we have poverty challenges, we are going to have to devote resources to adaptation, to resilience, and to other sort of climate objectives. So it's going to be a challenge, but it's one that we're quite willing to take, and we're willing to take on that challenge to ensure that multiple objectives are met.
Great. Thank you. So now we're going to turn to a third group of countries that Lisa's been very involved with. So I want to know from you, Lisa, what is the legal nature and effect of the 1.5 degree aspirational goal that small island and developing states, or SIDS, as we'll talk about, fought for, and how, if at all, might be given operational relevance through the agreement? What's the perception of the Paris Agreement and international climate law from the point of view of some of the most vulnerable states, such as SIDS? Where are we at with loss and damage given the extreme events in the Caribbean this summer? You've already referenced it somewhat before, but I want to focus in on that loss and damage issue as well.
1.5 is obviously very near and dear to the hearts of small island developing states. The slogan that the Alliance of Small Island States uses is 1.5 to stay alive. So that is really our existential threshold for temperature. And the reference in the Paris Agreement of 1.5 was very hard fought for. 1.5 and loss and damage were the two red lines for small island states. We were not going to sign on to the Paris Agreement without it. So there's kind of a compromise on loss and damage between the COP decision and the Paris Agreement. But 1.5 really started in the Cancun negotiations, where small island states wanted to start an expert dialogue to look at 1.5, and that sort of push to really keep 1.5 in the forefront of the long-term temperature goal has been a constant struggle for SIDS. So there was an expert dialogue, but even in Paris, when you had these meetings of the subsidiary bodies, they didn't want to refer the outcomes of the expert dialogue on 1.5 to the COP. And so there was a hard-fought struggle even within Paris, which is very high profile, to get 1.5 referred to the COP at all, and then to get it into the agreement. So it is an aspirational goal only. Its legal relevance is minimal because there's no obligation to achieve it, and I think it is an important marker, but I think it's an important marker, as I said, of the ambition gap. And so when we get further and further away from it, I think it's really important to highlight that, particularly at the global stock takes. How far away are we? And so what the next step for 1.5 is the IPCC special report. And so the special report for the IPCC, again, was hard fought for by SIDS, but if you look at the actual structure of the report, that was a disappointment for SIDS because there's only one chapter in the IPCC report that looks at the impacts of 1.5. And there is a substantial differential between 1.5 and 2 for SIDS. And so only having one chapter, even in the IPCC report, was a real disappointment. And, IPCC is a political forum as well. And so that was disappointing for SIDS, but we do have one chapter on impacts, and so it's important for us to see how feasible 1.5 still is. What we have to do to achieve 1.5 will really have to happen in the next 10 years. We are really quickly running out of time to phase out coal, to completely transition to electric cars, to do all these things that are really going to be big asks, particularly without large emitters being on board. So 1.5 is important, but it is will really be highlighted next year in 2018 when we get the report to see how far away we really are from 1.5 and what's really going to happen. The corollary of that, of course, is loss and damage. And so if we don't hit 1.5, there will be more and more loss and damage occurring in developing countries, including in small and developing states. And often states that are highly exposed and have limited adaptive capacities are the ones that are going to suffer the most. And so, again, loss and damage was an important anchor to have. SIDS wanted it in the Paris Agreement so it could have permanence. The Warsaw Mechanism on Loss and Damage was sort of an informal committee, and it wasn't really mentioned in a legal document, and so anchoring it as a separate article in the Paris Agreement to give it permanence was really important. But the mandate of the actual mechanism is controversial because, of course, liability and compensation, which is always sort of the elephant in the room when you talk about loss and damage, was excluded in the COP decision. And that was the compromise, is that loss and damage could be in the Paris Agreement, but liability and compensation for it would be excluded through the COP decision. Now, what the legal ramifications of that are is very unclear. That was a political compromise that had to be met in order for loss and damage to be included in the Paris Agreement at all. But what seems to have happened, COP23 is an islands COP, But getting loss and damage on the agenda of an islands COP was a struggle, which is just insane. I mean, it's just crazy. So getting it on the agenda at all was difficult. What seems to be happening is that loss and damage is being boxed into a technical issue only. And so loss and damage, the executive committee of loss and damage reports once a year to subsidiary bodies, and it's a technical report only. There is room for technical reports for loss and damage, particularly some of the work that I've done recently with a colleague is looking at policies and mechanisms in small island states for loss and damage. And what we are finding is that we simply don't have the data to figure out what our baseline is for ocean temperatures, slow onset effects. We have meteorological data. We simply don't have any data to measure the loss and damage that's happening. We don't have enough research going on, and so that, there is room for the mandate of the WIM to increase research and accumulate data on loss and damage so we know what we have and what we're losing and how quickly we're losing it. So that is important. But there's also another element of loss and damage which we've seen this summer, basically, in the Caribbean and, subsequent years before, and also in other countries. So, Bangladesh was a quarter underwater, the monsoons in India, the heat waves, the wildfires in California, and of course the hurricanes that have hit the Caribbean this summer. Last summer, I found myself hiding in my bedroom cupboard as a Category 4 hurricane hit my house, and I was wondering if the roof would fall off. And then the summer before, we had Hurricane Joaquin in the Bahamas. So we've had 3 years of major hurricanes hitting just one country, and of course we had Irma and Maria that really devastated the Caribbean. And the big question, particularly for sovereign countries that don't have wealthy patrons like Puerto Rico with the U.S. or the British Virgin Islands, is who's going to pay for this? I mean, how are we going to rebuild from the impacts of these extreme events? And of course, climate change is an accelerator of these events. We haven't had categories like this. I think, Maria, it was off the chart. I mean, it was Category 5, but it was sort of above the Saffir-Simpson scale. So they're going to have to recalibrate the scale for hurricanes because of the intensity, and we're simply not prepared with our building codes or relief and disaster recovery efforts. And what happens in a lot of developing countries, but particularly SIDS, is we don't have dedicated disaster funds. And so when you have disasters, money is pulled from public budgets of existing departments. And so you have less public money available. And so you get money pulled from development objectives. And so I call it this sort of unvirtuous cycle of capital erosion and reduced climate resilience, because you have a disaster, you got to pay for it somehow from your own public budgets. We do have an insurance mechanism in the Caribbean, but it doesn't pay for a significant amount. So you pull public money from other development objectives, which means that you have less money for things like climate change adaptation, poverty reduction, education. There are cuts, public cuts, and that means that you are less resilient to climate change impacts, and then you have another disaster. So the cycle just it's rinse and repeat. And so you have highly indebted countries that just cannot afford to pay for this anymore. And we are now in the realm of climate disasters. So you have islands like Barbuda that have not, 300 years for people have been living on it, and now there's nobody there, and they don't know if they're actually going to be able to move back because nobody knows who's going to pay for it. And you have Dominica, of course Puerto Rico has made the news a lot, but you have countries like Dominica, and it's the other Caribbean countries that are taking in refugees. So we are not only absorbing the cost from our public budgets, which we can't afford to do. We're being downgraded financially. We have very few economic diversification options, and now we're accepting refugees from our own region. And so, I mean, it's just a cycle that's continuing, and yet the political agenda of loss and damage just cannot make it into the negotiations. And so there was a real fight by SIDS to get loss and damage raised at every subsidiary body agenda item, and it was just shut down by developed countries. And so even though we have loss and damage as a hook in the Paris Agreement, we are really struggling to get it to the attention of regular attention at the global level. So it's a really dire situation. It's concerning. It's highly political and highly sensitive, and it's not getting better. It's actually getting worse as you have more and more extreme events. So it's not positive.
Yeah, so on that note, we are now at 11 minutes remaining. And I assume people might want to interact with you, though I'm guessing it's going to mostly happen over lunch informally. I'm being strict, Jackie. So the last question I have for you, and if both of you can try to keep your answers brief, is in 10 years' time, where do you think we will be with the development of climate law? And how might we design a compliance and implementation mechanism under the Paris Agreement that is tailored to the hybrid nature that you've already referred to of the Paris Agreement's legal provisions?
Well, in 11 minutes for both of us.
Yeah.
Okay, that's again.
Probably 10 and a half.
Okay, so that's a vast question. I also remembered as Lisa was speaking that I didn't address the equity question in your previous question because there's sort of lots of different elements to that question. So let me just briefly address equity and then come back to this vast area very briefly. So on the equity question, the Paris Agreement doesn't actually lend itself to very serious determinations of equity or burden sharing because I think the whole effort behind much of the politics that led up to that final deal was to ensure that we sidestepped the equity and differentiation question rather than addressed it head on. That was the political deal there. So the self-differentiation sort of represented in the fact that countries chose their own NDCs also meant that you couldn't actually determine how you'd sort of divide up the burden between countries. So there isn't as much scope as you would hope for addressing the equity question in the Paris Agreement. The one sort of hook that some developing countries managed to get in, particularly the African nations, was equity in the global stocktake. And there was actually a robust discussion on this, not much movement, but a robust discussion on this in COP23 on how we introduce equity elements into the stocktake process. But as Lisa has mentioned earlier, the stocktake process is a sort of collective assessment. It's not an assessment of what individual countries do. And so far what we've had through NDCs is just countries justifying why they think their actions are equitable and fair. So even the assessment of equity is a self-determined assessment, or the assessment of fairness is a self-determined assessment. So the African group of nations actually has looked at some of these, and some of their researchers have looked at the ways in which countries have justified why their sort of NDC is fair and equitable, and said, well, actually most countries are using a set of 6 different indicators, so maybe we can draw from the ways in which countries are actually defending their actions as equitable and fair to actually have a framework through which we assess it at the global level. I'm not sure how far it will go because this is actually a very sensitive topic like the loss and damage topic. Burden sharing is sort of one of those topics that a lot of developed countries are quite allergic to. So we may not get far with it, but at least that conversation is happening, and that's one scope for equity to be sort of reflected in the final sort of agreements and NDCs of parties. On loss and damage, I just wanted to say, just briefly, Lisa has sort of done a wonderful sort of survey of the key issues there and her assessment and sort of pessimism about it. I think one of the concerns with it is that, that I think for developed countries, they really don't want to have a conversation on compensation and liability. So as far as loss and damage is addressing knowledge sharing and, all those lovely, fuzzy, warm, topics, it's fine. But as soon as you start actually discussing sort of compensation and liability, it's a no-go area, which was reflected in the deal between the COP decision and the relevant article in the Paris Agreement as well. So I think the conversations have to be around solidarity, sort of addressing the kinds of concerns, but do it through solidarity and philanthropy rather than through sort of liability and compensation. It's unfortunate, but that seems to be the red lines of many parties on that. Finally, in terms of where I expect climate change law to be in 10 years, I think climate change law, where I expect it to be in 10 years, is one question. I think where I expect how we address climate change is a different one. I'm not very optimistic about how effectively we'll address climate change in 10 years. But climate change law, I'm sort of optimistic that we might actually get further along the line. Hopefully we'll have sort of a robust system of rules under the Paris Agreement, relatively robust, a tried and tested global stocktake process, which perhaps includes some equity elements. And at the domestic level, which I think is very important for the Paris Agreement's implementation, to have sort of climate legislation, policy, and practice in a large number of countries. Already there are lots of countries with climate legislations. And at the domestic level, I think hopefully it can fill in the gaps at the international level and ensure implementation of NDCs. And I think that's as far as we can expect things to go in 10 years. As far as climate change law is concerned, the international negotiations do happen to fairly glacial progress.
Thank you. That was very disciplined. I thought we were at 3 minutes. So, Lisa?
I think I'll probably just focus on the compliance and implementation mechanisms. Mm-hmm. The only thing I would add on the progress of climate change laws, I think it's interesting. It's sort of filtering outside of the UNFCCC process now. And particularly with climate litigation, is really gaining speed. I think some of the fiduciary obligations of directors has become very interesting. Institutional investors becoming concerned with climate change. So I think it's sort of creeping outside, and I think that's a really interesting development, and hopefully that can sort of push ambition outside of the glacial pace of negotiations themselves. I think that there is an opportunity for the implementation and compliance mechanism to sort of tie together some of the collective and individual obligations. And this is a very difficult issue, particularly for the mechanism. A lot of the negotiators have changed in this area, and so I've heard some comments that, well, it's not about compliance, but actually the mechanism is about facilitating implementation and promoting compliance. That was very clear and very hard fought for, that compliance is in there. Maybe a facilitative, non-punitive approach, but it does talk about promoting compliance. And so I think negotiators may have possibly conveniently forgotten about that part of the mechanism itself. And so there were some really interesting discussions at COP23. A lot of questions were asked by the co-facilitators about the universality not only of the scope of the obligations that will be subject to the mechanism, but the number of countries. And so you have to have the mechanism be both flexible. How is it going to take into account differing capacities of different countries? Is it going to look at countries on a case-by-case basis? Are countries going to sort of self-declare their capacity constraints? But it's also got to be predictable as well and consistent. And so it'll be a really interesting approach that they take. And so how do you determine if a country just doesn't have capacity or doesn't have will? How do you assess that when they come, and submit things before you? So there were a number of roles that were sort of debated at COP23. The mechanism could give advice, it could share experiences, it could actually issue statements, which people said, oh no, a letter would be punitive. You can't write a letter to my government, that would be punitive. It's like, come on, it's just a letter. But the other interesting part of it is it's supposed to be participatory. And so one of the weaknesses of the facilitative branch at the moment under Kyoto is that you can write to a country and they just don't write back. But this mechanism is supposed to be participatory, so countries are supposed to engage in the process. It's supposed to be facilitative. And so I think that will be a really interesting element to it. I think one of the potentially interesting roles that the mechanism could play is a systemic role. And so there will have to be engagement between the different mechanisms. So the output of the transparency mechanism is obviously going to feed into the implementation and compliance mechanism. But there are other mechanisms that could be joined up through the compliance mechanism as well, like the capacity building mechanism, the finance mechanism, the technology mechanism. There is a potential role of the Compliance Implementation Committee to look at systemic barriers, particularly for developing countries, of how they're achieving their NDCs. And I think if it could, and that is where it could analyze collective obligations in a sort of very facilitative manner, saying, these are the systemic issues that we are seeing, and so collectively this is why we are not meeting the goals that we have as a result of outputs from the global stock tape. So I think that could be a really interesting role. Whether or not that gets achieved is another question, but it's something that was really debated at COP23, and I'm trying to be hopeful in terms of the mandate and the scope of the mechanism.
One point of compliance?
Sure. Since we have 3 minutes?
Yes, since Lisa didn't use up all the 3 minutes.
We'll share.
Thank you. Good sharing.
Collaborative nature of this conversation.
So I think actually, in addition to the issues that you raised on compliance, one of the interesting issues also, given the hybrid legal character of the provisions in the Paris Agreement, is what will the compliance and implementation mechanism actually apply to? So as I said, there are provisions in the Paris Agreement that are just sort of have a narrative function or a storytelling function. So does the scope of the mechanism, extend to all provisions of the Paris Agreement, or only those provisions of the Paris Agreement that actually contain legally binding obligations, whether of conduct or of result, whatever kind of obligations? And I think the sort of emerging consensus on that is, although it would make sense to limit the compliance and implementation mechanism only to those provisions that lend themselves to compliance and implementation sort of questions and assessments, the fact is we're never going to be able to agree on which those provisions are. So, and since we can't agree on which those provisions are, we're going to sort of let the system determine which provisions actually the mechanism is going to apply to. But it's an interesting sort of legal question, I think, because you have all these sort of context, and narrative sort of setting provisions that are in the agreement, and how do you actually have compliance systems apply to them?